This is a first-party insurance claim brought by Ed and Marla Laur against Safeco Insurance Company of Indiana. The Laurs assert that Safeco wrongfully denied their claim based on several inapplicable exclusions from the policy. At the district court level, both parties moved for summary judgment on coverage. The district court granted summary judgment on coverage on the basis of at least one of these exclusions. And based on a finding of no coverage, the district court also granted summary judgment on the Laur's extra contractual claims. Because none of the exclusions cited by Safeco or the district court can properly be applied, the Laurs asked this court to reverse the district court, render summary judgment in favor of the Laurs on coverage, and remand for determination of damages on coverage and for determination of liability and damages on the Laur's extra contractual claims. As to exclusion 2, which applies to freezing to a landscape sprinkler system and has an exception for any resulting loss, that exclusion does not apply because the resulting loss exception is applicable. As discussed in the briefing of both Safeco and the Laurs, a resulting loss, which is also known as an ensuing loss, is a secondary loss that would ordinarily be covered, but results from a primary loss that would be excluded. The example that Safeco discusses in their briefing is that of fires sparked by earthquakes in San Francisco. In that type of scenario, you'd have an earthquake, which is an excluded peril that causes, say, a gas line to break. The release of gas from the gas line then sparks a fire. The fire in that case would ordinarily be a covered loss, and the exception applies to show that even though it was initially primarily caused by an earthquake, which is excluded, this subsequent loss would ordinarily be covered, and under the resulting loss exception, it is covered. In this case, we have a freeze event to a landscape sprinkler line. Ordinarily, that is a non-covered loss. That sprinkler line, once broken, released water which flowed under the Laur's concrete slab and into their basement, causing water damage to the basement.
Wouldn't that happen every time a sprinkler system burst because of a freeze?
No, Your Honor. There's no reason that the water would necessarily flow into the basement and cause this type of damage. A sprinkler line could be shut off entirely and not even release water once frozen and broken. It could just be broken and need to be fixed.
Well, if you drain the water pressure, it won't burst, before it freezes. But, my point is, I guess I'm struggling to see how this is a resulting loss or an ensuing loss, because it just seems like it's a loss. And I think that's what the district court concluded, right?
Actually, the district court concluded that these losses were separate losses. The
district court, it said the one begat the other. I'm not sure that that's really a separate loss. In other words, the sprinkler system ruptured and it caused the damage to the basement because the water flowed.
Yes, that is correct. But the standard for whether it's a separate loss or the same loss is whether it's necessarily tied to the other in a way that it can't be separated. For example, in, I believe, the Balfour case, there was welding slag that fell from the roof during the welding operations. The excluded peril was the welding operations, and the falling slag damaged the windows. The insured in that case attempted to argue that the falling slag is one loss and that the damage to the window is a separate loss. But the court correctly found in that case that the operations included the falling slag, which damaged the windows.
How did the burst sprinkler not include the flowing water?
Because the water could have been shut off, because the water could have gone elsewhere, because the water could have been shut off before, after the freezing incident, but before the damage occurred to such an extent.
So assume we agree that it's a resulting cause, the water is separate. Your argument is that therefore it's covered, even though the sprinkler system rupture is not covered. How do you survive the exclusions, though, that say that flood, surface water, subsurface water, not covered?
We acknowledge that if any of these exclusions apply, then there's no coverage, but we disagree that these other exclusions apply as well. The coverage for water control device, for instance, the court, which is what the court primarily relied on, the court said that the provision that excludes a release of water held by a dam levee or dike or by a water flood control device, included a sprinkler system as a water control device. Under the applicable rules of construction, you have to look at items that are like a dam, dike, or levee for that general term at the end.
That's 9A2, but what do you do with 9A1?
Under 9A1 as a surface water, the water at issue was not surface water because it does not meet the definition of surface water. Surface water has been defined as water or natural precipitation diffused over the surface of the ground. In the
Is there a
side
definition in the policy or the definition from dictionary?
that's the definition under state law, Your Honor, which is also consistent with the definition of surface water in American jurisprudence and is generally accepted in insurance policies. In the Psy case, which both parties cite to, the water originated from the normal operation of a sprinkler system where the water was sprayed out of the nozzles and spread over the surface of the ground, where it flowed erratically and then eventually made its way into the dwelling.
I thought there it was mixed with rain also.
Yes, Your Honor, there was a question about whether it was mixed with rain as well.
Rain would clearly be surface water.
Yes.
Use and all those kinds of things.
Yes, Your Honor, and
Well, how's this not a flood?
it's not flood, Your Honor, because a flood is a specific type of water event, not just any water damage where it shouldn't be.
Where does it say that in the policy?
The policy does not specifically define flood, but the term flood is included within 9A1, where it says flood, surface water, waves, tidal water, overflow of a body of water, or spray from any of these, whether or not driven by wind, including hurricane or similar storm.
But the policy, I'm sorry.
Go ahead, you go ahead.
The policy also says whether man-made or man-caused or naturally caused.
Yes, Your Honor, you could. I believe you could have a man-made flood. Say you had a very large water storage tank that broke and then released a mass of water across the surface that rushed onto the Laur's property.
Didn't the basement flood here?
The basement was filled with water. It was flooded, but not by a flood. A flood is a specific event, especially in the insurance context. And under Texas law, the George case in particular talked about how a flood denotes a rising or overflowing of a body of water or an overwhelming quantity or volume. And in that case, rain filled up a drainage ditch that then overflowed and the water coursed onto the Laur's property. Here, Mr. Laur estimated that there was approximately 36,000 gallons of water that filled up the entire basement. If a 36,000 gallon mass of water had coursed onto the Laur's property, it wouldn't have been able to make its way between the surface of the ground and the slab to enter the basement. It would have run up against the house and then dissipated and flowed back down to the alley, and they wouldn't have had nearly this level of water intrusion. We can't just say that any intrusion of water where it shouldn't be is a flood, or you end up in a situation where all water damage can be called a flood. But a flood has to have these specific characteristics that make it a flood.
What do you do with 9B?
The water below yes, Your Honor, the water was not below the surface of the ground really under any way you can define it, I don't think.
Well, I mean, Safeco says it's either above the ground or below the ground, one or the other, but both are excluded.
And that's a false dichotomy, Your Honor.
Which was it then?
It was neither. It was water. It's water at ground level, but that doesn't make it surface water because, as we've discussed, surface water is diffused. It's a specific type of water. And water below the surface of the ground, even in the loosest sense, you have to have water that is below some surface. Safeco hasn't even identified the surface under which it says the water was below.
Oh, but your client said it was below the ground. The pipe that burst is below the ground.
Our client said that the pipe itself was below the ground, but Mrs. Laur also specified in her deposition that the actual origin of the leak, where the pipe broke, was in a valve box that kept the dirt out. And that valve box was contained within a concrete cutout with a metal lid on top in their patio. So
Wasn't that below the surface also?
It was below the surface of the valve box lid and below the surface of the concrete, of the metal lid, but it wasn't below the surface of the ground. The water, so the origin point was not below the surface of the ground. The water then flowed between the surface of the ground and the slab as specified by Safeco's own leak investigator and made its way to the Laur's basement. So the path the water took was not below the surface of the ground either. And the water damage itself did not occur below the surface of the ground. It occurred in the basement. In a lot of these types of cases, you end up with water that has seeped in below the foundation and causes settling. That's not what occurred here. This is straight up water damage that occurred to the structure and the contents of the basement. And so there's really no, I don't understand what surface of the ground the water will be below. Safeco, they could be trying to argue that any water that ever passes through a pipe that is buried is water below the surface of the ground, but that would entirely contradict all the other provisions in the policy that cover water damage. And in particular, I mean, the Safeco had previously covered some damage to the basement that arose from a washing machine leak, and that water would have come through the same main line that the water came through in this case. And so the water was simply not below the surface of the ground. And so none of these exclusions, either 2 or 9, apply. And so since none of these exclusions apply, this court should grant summary judgment in favor of the Laurs as to coverage. Safeco alternatively moved for summary judgment in the event there was coverage on the Laurs' bad faith claims, arguing that they had a colorable defense to coverage. But the standard for bad faith is not whether there's a colorable defense to coverage. It's whether or not an insurer knew or should have known that it was reasonably clear that a claim was covered. And the Texas Supreme Court has held that there is some evidence of bad faith where an insurer contradicts the terms of the policy or the facts. And here, Safeco did both. Safeco's adjuster said to the Laurs that there is no coverage for the damage to the sprinkler system and no coverage for any resulting loss. And so doing that, Safeco's adjuster was recognizing first that this was a resulting loss, and second, it was misconstruing the policy and saying that there wasn't coverage when there was. Additionally, the adjuster contradicted the leak investigator's report when he said that when the adjuster said the water was below the surface of the ground, when the leak investigator's report said that the water flowed between the surface of the ground and the slab. I would also point out that the slab itself is not the surface of the ground. The policy includes, I think it's important to note, a foundation water damage provision that differentiates and actually provides coverage for leaks that occur under the slab from a plumbing system. And so just because it's below the slab doesn't mean that it's below the surface of the ground. Water below the surface of the ground means water that seeps into the ground or creates an underground body of water of some way, whether from a natural origin or a man-made origin, but it has to be in the ground in some way or the other. So the insurance adjuster in this case did contradict the terms of the policy and the facts, and that should be some evidence of bad faith that allows this case to be submitted to the jury on the question of bad faith, which is really a question for the jury on when the insurance company should have reasonably known it should pay this claim. In addition, the Laurs moved for summary judgment on Safeco's affirmative defenses. What the Laurs did was they pointed out that there was not legally sufficient evidence of various defenses and explained why the evidence that Safeco was presenting was not legally sufficient. And that meets the burden set forth in the Celotex case for moving for summary judgment on something on which you do not have the burden. Safeco, in this case, both because they were exclusions and because it was Safeco's motion for summary judgment to establish those exclusions, Safeco had the burden to establish the applicability of these exclusions and the burden to establish any of its affirmative defenses. And so the Laurs properly met their burden to force Safeco to show how its defenses applied. And Safeco did not present any legally sufficient evidence to support those affirmative defenses. The district court erroneously shifted the burden back to the Laurs and said that the Laurs didn't put on evidence to disprove their burden, but under the proper standards, Safeco's affirmative defenses should have been denied on summary judgment. And so for those reasons, we would ask this court to reverse the district court, remand the case to the trial court, and rule in favor of the Laurs as to coverage.
All right, counsel. Thank you.
Thank you.
Okay, good morning, Your Honors. My name is Kieran Leary, and I'm with Aaron Stendel here on behalf of the appellee, Safeco Insurance Company of Indiana. To us, this is a relatively simple case. This is a water leak from an underground water pipe that caused water damage to a property. There's two clear exclusions here that apply to prohibit coverage. That's a water damage exclusion and the freezing to a landscape sprinkler system exclusion. And simply put, if one of these applies, there's no coverage for this claim, and it's our position and the district court's position that both of these applied in equal force to bar coverage for the Laur's claim. And I'll touch.
Also, let me ask you about the inspection that was done and the conclusion about identified causes. The water from this ruptured line appears to have run at ground level between the soil and the concrete foundation of the patio, so below the concrete of the patio, above the ground. Followed the ditch line that contains the fresh water supply line for the dwelling, enters the dwelling, and that's how it got into the basement. I'm not sure if that's surface or subsurface, if it's either. I mean, maybe it's neither, which is the point being made by opposing counsel.
Yes, Your Honor. And we'd address that by noting, number one, that
Accepting that, there's no contest. Both sides paid for this inspection? I don't know, but both sides agreed to it.
Safeco paid for it, Your Honor. Both sides agree that's the language contained in the Leak Detection Services report. It's important to note that in the Laur's demand letter sent prior to suit, as well as their complaint in which the demand letter is incorporated as an exhibit and thus part of a complaint, the Laur's address that this water was a flood. They note that they take issue with the exclusion for water below the surface of the ground, and they say that that only applies to water losses caused by or resulting from natural events or precipitation, not human or animal forces. Well, Safeco's policy language is different and contains an additional requirement that the below the surface of the ground or surface water exclusions apply whether caused by or resulting from human or animal forces or any act of nature. Once the Laur's realized that exclusion would apply to a man-made pipe, they sort of shifted the argument.
Wait, that's what the Laur's say, but what about Judge Southwick's question? What about your inspector and what he said? What does he say that means when it runs at ground level and then to the back patio and then to the basement? Is it surface water or is it not? The counsel opposite says it's not.
Yes, Your Honor. It's Safeco's position that this is surface water and
Surface water.
Yes, Your Honor.
Is it subsurface water?
The facts and evidence in this case also demonstrate that the water was below the surface of the ground.
Both?
It can be both, Your Honor, because of the anti-concurrent causation lead-in provision of a policy, which states that Safeco does not cover loss caused directly or indirectly by any of the excluded perils listed, including below the surface of the ground or surface water, and it applies in equal force whether the cause of loss or any other cause happens concurrently or in any sequence to the loss. So we acknowledge and also cite to the American Leak Detection report that this water ran at ground level at some point. But simply put, if the water at any point in time ran below the surface of the ground, and we have statements from the Laur's, testimony from the Laur's that it did, that its pipe was below the surface of the ground, then it would be excluded as water below the surface of the ground per the subsection that excludes water below the surface of the ground because of that anti-concurrent causation lead-in provision. And we've had two Texas state appellate courts, both the Austin Appellate Court and the Houston Appellate Court in the Cy versus Liberty Mutual matter, as well as the Safeco versus Moss matter, which recognized this anti-concurrent causation lead-in provision. So,
did the break in the sprinkler occur in the box? Counsel just described that there was a box that had a lid on it that is not below the ground. Is that where the actual break in the sprinkler system occurred? Or are you saying it occurred somewhere in a PVC pipe somewhere under the ground?
Your Honor, the testimony in this case was when Mrs. Laur was asked, is a pipe that froze and leaked below the surface of the ground? She stated yes. So it's our position that this pipe was below the surface of the ground, and thus the water at one point in time.
Counsel, let me ask you again. Was it in the box that counsel described that is not below the ground, but rather has a lid on it. I think we're all familiar with sprinkler systems generally, that there are pipes under the ground, PVC pipes that run out to sprinkler heads, but there's also like a junction box that contains a lot of equipment and
Yes, sir.
valves and whatnot. Where was the actual break in the sprinkler system as a result of the freeze? Was it in the box, or was it under the ground in a PVC pipe?
Yes, Your Honor, and I don't think the testimony is clear as to that point, and the American Leak Detection Report certainly it also is not necessarily clear as to the point of
Your
origin
guy
for the...
says it was in the valve box in the backyard.
Okay.
Is that the valve box we're talking about?
I believe that would be the valve box, Your
Is there
Honor.
evidence that contradicts that that's where the break was?
Other than what's in the American Leak Detection Report, there would not be anything of substance as to where the break in the pipe would be.
Can I ask you a more general question?
Yes, sir.
I read through the briefs in this case, looked at the policy and all the exclusions and the various provisions that you all are relying on and arguing back and forth. Is there anything in this policy that covers damage when something gets wet?
Sure, Your
Water
Honor.
from the air, water from the flood, water from underground. It seems like despite all of the exclusions and exceptions to exclusions, at the end of the day, 6 days to Sunday, there's no coverage when something gets wet.
Well, Your Honor, the policy would provide coverage in a scenario, let's say you have a hailstorm or a windstorm, and that creates a storm-created opening, and rainwater then enters the building. That's the sort of event that would be covered under our policy. But events such as infiltrating groundwater, water below the surface of the ground, outside water moving into the property in those manners, those are explicitly excluded under our policy. And again, I come back to a point, it's Safeco's position this water was both below the surface of ground at one point in time, and it also ran at ground level. And if it did either of those, and it has to be one or the other, this is an excluded loss because of that anti-concurrent causation lead-in provision.
The thing I would say is it doesn't have to be one or the other based on your inspection report. It sounds like it ran under concrete. So it's neither on the surface nor was it underground. It was under concrete of the patio. But I will say the inspector does indicate, I don't quite follow when it enters the house, but perhaps that's where it becomes either surface or underground water. What do you say to the point, is this underground or surface cover under concrete?
Your Honor, I would not cover that scenario because it's at the surface and it's also below the surface of the ground. And
It's not on the surface. It may be on the top part of the dirt, but it's not on the surface.
well, Your Honor, Safeco's position would be if it's at the top of the dirt, that's at the surface. And we'd rely again on that Cy versus Liberty Mutual case, as well as a Safeco versus Moss case that we've cited, where the Houston Court of Appeals in Cy stated that surface water as used in an exclusion of homeowner's policy would reasonably include rainwater that had collected on the surface of a raised patio before flowing into the insured's home. In Safeco versus Moss, you had a situation where there was natural precipitation that flowed along the surface of the ground, and as a result of gravity, then eventually made its way into a man-made structure, which was an electrical conduit, then moved into the Moss's home. We had a Valley Forge versus Hicks case that we cited as well, where water did not lose its character as surface water when it flowed from the surface through pedestrian channels and into other man-made structures before flooding the insured's premises. And I think that flooding word is really an important point in this argument that we're making. The Laurs repeatedly refer to the event that happened at the property as a flood. We've both cited to this George versus State Farm Amarillo Appellate Court case where the court noted that flood is not defined in the policy. As such, they accorded it its ordinary common definition, which is an overwhelming quantity or volume of water. That's this case here. In George, a ditch filled with water, then eventually, the term eventually is emphasized by the Amarillo Court of Appeals, overflowed that ditch, then entered the George's basement. And they noted that even though it was a relatively small amount of water, but policy doesn't mandate an overflow of biblical proportions like that experienced by Noah or that experienced, unfortunately, by this city in Hurricane Katrina. And it's important to note the Laurs are entitled to make alternative arguments, but what they should not be entitled to, Your Honors, is alternative facts. When they argue against the flood exclusion, they state that it was a mere leak. But when they're trying to make this into some sort of ensuing loss, they argue that this was a flood, an overwhelming event that was a distinct peril from what was experienced when you simply have a freezing of a water control pipe that results in a water leak and a loss. And they can't have it both ways, Your Honors. We'd also note that the policy excludes coverage for loss caused from a water control device. And the sprinkler system controls water. I don't think the Laurs would dispute that, or
It's not a dam, a levee, a dike. I mean, how does it really fit in that clause of A2, 9A2?
Your Honor, I understand the argument that meaningful words are inferred by what surrounds them, and that nascitur scholicis, part of my Latin, is one manner of contract interpretation.
Words known by the company it keeps.
Right. Yeah. Yes, Your Honor. And I note, though, that the freezing to a landscape sprinkler system provision also includes freezing to a swimming pool, a fence, a landscape sprinkler system, a pavement, a patio. So the company it keeps exclusion or contract interpretation in that scenario wouldn't necessarily have the same import or align with that sense of contract interpretation for the water control device exclusion. But moving along into the freezing exclusion, because I think we've touched on the water damage pretty extensively here, both parties agree that this claim is barred from freezing to a landscape sprinkler system. We agree that this exclusion applies, but the Laurs, and it's their burden to prove an ensuing loss, are arguing that the subsequent water entrance into their basement constituted a separate, distinct peril that would grant back coverage for them. And we all know from the Balfour Beatty case that this court had in 2020 that a resulting loss or ensuing loss clauses are one and the same. And here you only have a singular loss, a rupture in an irrigation supply line. Their ensuing loss theory is essentially a water loss that causes a water loss. The origin of ensuing loss clauses provides a sound example of what we're looking for in order to have actual ensuing loss. Back in the San Francisco earthquake of 1906, earth movement was excluded. As a result, there was earth movement that begat a number of fires in San Francisco, and some insurers, but certainly not Safeco Insurance Company of Indiana, argued that those fires would not be covered because they were derivative of that original earth movement loss. And eventually, insurance companies and regulatory agencies looked at this and said, you know what, that's not really equitable. So they gave rise to the birth of ensuing loss clauses. But it's important to note that they do not resurrect coverage. The grant back exception known as an ensuing loss cannot swallow and or supersede the exclusion. And the example given by this court in Balfour Beatty is a really good one as to what you're looking for an ensuing loss. It could be a loss caused by an act during a renovation that causes a covered peril, such as a fire, and that latter peril damages the building. But courts will disallow coverage for a purported ensuing loss that's directly related to the original excluded risk. And in terms of a Laur's claim, what could be more related to the original excluded risk than a water leak from a water pipe causing water damage to the property? Instead, this court has repeatedly recognized, most recently in Balfour Beatty, that there must be some distinct peril that arises as a result of that excluded peril, and that subsequent distinct peril must be covered under the policy. However, this court cited extensively in Balfour Beatty to a Connecticut appellate court decision in Viking Construction, where the damage to the windows of a building was concomitant with the power washing of those windows. In Balfour Beatty, the damage to the exterior glass was concomitant with the welding operations. Here, the damage to the Laur's property caused by their water leak was concomitant with the leaking water pipe. There is not a distinct peril, and even if there were, water damage is excluded under a policy, whether it's below the surface of the ground, whether it's at the surface of the ground, it's a water control device, and or it's a flood. As a result, the Laur's fail on all counts. They don't have a separate distinct peril, and they don't have a secondary peril that's covered under the policy.
Counsel opposite to say that Safeco had covered a leak in the washing machine or a leak in the pipe to the washing machine before?
Your Honor, I don't believe that's extensively part of a record or something that's briefed by the party, so I wouldn't necessarily want to be held to this, but I do remember that the Laur's did have a prior leak inside of their property. But we're talking about water infiltrating.
Well, that's what I was going to ask.
Yeah.
I mean, you can call it a hypothetical then. I mean, if that were to be covered under the policy, what is the distinction between that and what we're talking about here?
Well,
water would have flowed below the ground and the pipes coming into the house, right?
Well, so if you have a leak from a washing machine and it's inside the property, that's not water below the surface of the ground, or that's not water at the surface level. That's water inside the actual dwelling, which is above surface level and not below the surface of the ground. I think in order to have a more informed response, Your Honor, I would have to have that set of facts directly in front of me so that the Laur's could direct us to how that should be interpreted. But I would note that even in circumstances where an insured does where an insurance company gives an insured the benefit of the doubt and extends coverage for something that might not actually be covered under the policy language, that doesn't necessarily give rise to the fact that they have to cover subsequent claims that are clearly excluded, like here. And as I've stated, even if the water damage exclusion doesn't apply in any of those subprongs, Your Honors, the freezing to landscape sprinkler system exclusion still clearly applies, and there's no secondary distinct peril. And the Laur's site.
We don't even get to the exclusions in 2 and 9, I guess, or 9, if there's no resulting cause.
Right. Yes, Your Honor. You don't even get to, if everyone agrees that there's no coverage after number 2, or that freezing to landscape sprinkler system is excluded, you don't get to the resulting loss clause. Alternatively, if you just decide that there's freezing to landscape sprinkler system and no subsequent secondary peril, then you don't even have to analyze whether the water damage exclusion is applicable or not. And I think it's important to note that the Laur's highlighted language in the policy that noted if loss to a covered property is caused by water, there is no coverage for the cost to repair or replace the system or appliance from which water or steam escaped. That simply states that certain property is excluded even if there's a covered loss. If anything, that provided more support that this is an excluded loss because a sprinkler system exclusion is broadly applicable. It doesn't limit coverage one way or another to specific building components. In fact, Laur's reading would render the freezing to landscape sprinkler system exclusion entirely redundant and superfluous because that provision I just read would state the exact same thing as freezing to landscape sprinkler system if the only excluded loss is that original freezing to the pipe. For the same reasons that there's no coverage to the dwelling, there's also no coverage for personal property under this policy because they are governed by the same policy language. We'd note that the district court had Magistrate Judge Reno and Judge Kaczmarek, 2 extremely terrific and learned judges, note that this policy language was conclusively applicable. It was relatively straightforward interpretation. Both judges who looked at this at the trial court level agreed with our interpretation, disagreed with the Laur's. We have 2 state court appellate decisions that granted summary judgment on largely analogous facts on the exact same policy language in Houston and Austin. We have an Amarillo appellate decision that granted summary judgment on an exact same flood provision where the flood event there was arguably relatively more nebulous than what we've encountered in this case. And it's important to note that the Laurs have cited a bunch of ensuing loss cases, but none of them actually agree with the Laurs proposition. All of them either result in summary judgment for the carrier, were dissenting opinions like Ballingran versus Safeco, and or were decided on starkly different ensuing loss provisions, some of which explicitly contemplated water damage as an ensuing loss. The ensuing loss provision here is not illusory. As cited in Balfour Betty, if you have a welding damage that results in a subsequent storm damage entering the property as a result of that welded damage, that's a covered secondary loss. Frozen pipe creates a fire, secondary distinct peril and a covered loss. This is not a illusory provision, and even if the court held that the loss could be of a different nature than that excluded, it is not an ensuing loss otherwise covered because they're going to run into that water damage exclusion. We note that there's no coverage, so there's no extra contractual liability under USA versus Menchaca. There's certainly no independent injury. Even if there were coverage as to the breach of contract count, which Safeco obviously strenuously objects to, this is a clear bona fide coverage dispute, so there would be no extra contractual liability. And I note just two last points. Number one, to the extent the Laurs argue that any of this language is ambiguous, they did not affirmatively plead that, so if not affirmatively pled, then their arguments are waived. And this court has established precedent that if there is potential conflict between the law of this court and established Texas state court decisions, particularly at the appellate level, that the court would look to certify insurance cases to the Supreme Court. But we think this is relatively clear based on the precedent we've presented to you, and I thank all of you gentlemen for your time. Thank you.
I'd like to point out first that the water damage to the basement is something that would ordinarily be covered under the general grant of coverage in the policy. The policy says broadly that it covers any damage to the dwelling and any damage to the personal property, and it's limited only by these exclusions. So if the exclusions themselves do not specifically apply, then there is coverage. Safeco, during this argument, has made the assertion that because the water flowed through the pipe and was therefore, this buried pipe, and was therefore below the surface of the ground at any time, it's water below the surface of the ground and not covered. That construction would lead to absurd results and essentially write out any coverage for any water that ever passes through a pipe into the house, which is clearly not the intent of the policy given the other provisions that provide for coverage from water that is released. It's simply not a reasonable construction. It's the same with any argument they make that the water being below the slab makes it below the surface of the ground, because the policy explicitly provides coverage in other areas talking about water below the slab when it's released from certain plumbing devices. And as discussed during opposing counsel's argument, the policy does provide a clarification about what these resulting losses are, saying that there is no coverage to repair the actual device in which the water leaked, but there is coverage to tear out and get to that device, which also indicates that when you have to tear out, say, a slab to get to the device that leaked water, it's not necessarily below the surface of the ground. And so the water does not meet those definitions of water below the surface of the ground to qualify under the exclusion. As to the related loss provision, Mr. Leary made the argument that these losses are concomitant and are directly tied together, and that they're both water losses, but they're not. Exclusion 2 applies to freezing to a landscape sprinkler system. The freezing, yes, it applies to the molecule H2O. It's not the same type of water that caused the water loss to the basement. You're talking about a very small quantity of water that is in the pipe that freezes and that breaks the pipe. We're not arguing that the freezing is separate from the pipe bursting and that the bursting pipe is the resulting loss. We're arguing that the freezing, which is concomitant with the bursting, is the initial loss, and that upon the bursting and thawing to allow the water to actually escape, new water that is not the same water that froze, 36,000 gallons worth, is what filled up the Laur's basement and caused all of that damage. And really, this is a textbook example of a resulting loss. I think what the most on-point case is out of this court in the Aetna case, where the exclusion was for rot or rust, and this court said that as an example of a resulting loss, that if you had a pipe that rusted and burst because of the rust, then the damage to the pipe itself would not be covered because that's excluded as rust. But the water damage caused by the water that was released from that pipe would be covered as a resulting loss. And so this really is a textbook example of a resulting loss, and which I think is emphasized by Mr. Leary's comment that if the frozen pipe resulted in a fire, that would be a resulting loss. But why a fire? Why not the frozen pipe resulting in water damage? They're both different. The freezing is different from the water, the freezing is different from the fire. And this resulting loss exclusion applies to any resulting loss, not just to fire. And if the policy had been intended to simply not allow any coverage for something that results from a sprinkler system pipe, then it would not have included that resulting loss exception, but it does, and so the court has to apply that. The last thing I'd like to emphasize is that there really are no factual disputes in all of this. It's really a question of how the policy is to be applied, and it's a reasonable construction of the policy to say that the water has to be actually below the surface of the ground, and to say that the water has to be diffused over the surface of the ground, or to say that the water has to actually be a flood and originate from a flood to apply this water damage exclusion. And in the event of, because the Laurs have offered a reasonable construction, this court has to adopt that if there's any ambiguity. While we didn't plead ambiguity, that's because we don't think the policy is ambiguous. We think the policy should clearly be construed in our favor. But if there is any ambiguity, it has to be resolved in the Laurs' favor. And so for those reasons, we'd ask the court to reverse and remand for further proceedings.
All right, counsel. Thanks to counsel to both sides. We will take a brief recess and then take up the last case.